All right, today we're going to discuss trial by written declaration. This is in California. This applies. There are several states actually that have trial by written declaration or something similar to it. In California, it's under the California Rules of Court, Rule 4.210. And anyway, I've said on my previous podcasts and my previous video cast that there are a number of reasons to do trial by written declaration. I really think every defendant in traffic court in California should do trial by written declaration. And let me say here as well that at the beginning, I'm not an attorney, so I'm not, charging money or anything like that. And I'm, in a technical sense, I'm not even giving legal advice. If I say things in here, it's in the context of what I've done in the past or what I would do if I had, if I got another California traffic citation. Since I don't live in the state anymore, it's probably not that likely that I'll get another one, but who knows, I might. Okay, so anyway, Rule 4.210. And then right at the beginning, it says this rule establishes the minimum procedural requirements for trials by written declaration under Vehicle Code Section 40902. The procedure established by this rule must be followed in all trials by written declaration under that section. And then the second section is procedure. And the first thing they're defining in procedure is the due date. And what that means, it says, is it's the last date on which the defendant's appearance is timely. And one thing about traffic court or court generally is you never, ever want to miss an appearance date. If you miss a date, you set up all kinds of nasty possible problems. And the first of them is you could get a bench warrant and you could actually be committing a misdemeanor or a much more serious offense than your infraction. For example, by not going to court by your appearance date. When you sign at the bottom of that citation on that yellow piece of paper, you're basically promising to appear in the court. And if you don't sign that, you will wind up in jail most likely. The officer will probably take you to jail because that signature is not admitting that you're guilty. It's just promising to appear on or before a certain date. And it'll tell you what time and where and all that stuff. You can go that day or probably several days later if you want to, but you must appear on or before whatever that date is. And as I've said before, the officer will not be there. That's just going to be a day when you can plead either not guilty or guilty, and you can post bail. And if you post bail, then they will. Anyway, I'm getting far afield now. Let's go back to trial by written declaration. So due date is the date on which your appearance is timely, the last date on which your appearance is timely. Number two, on extending the due date, if the clerk receives the defendant's written request for a trial by written declaration by the appearance date indicated on the notice to appear, that's your yellow copy, the clerk must, within 15 calendar days after receiving the defendant's written request, extend the appearance date 25 calendar days and must give or mail notice to the defendant of the extended due date on the request for trial by written declaration with a copy of the instructions to the defendant, which is form TR-200. TR-205 is the TBD form, and then TR-200 is the instructions to the defendant. You can get these online. And any other required forms, they'll send you those things. So there's some nice things there. It's within 15 calendar days, the clerk must extend the appearance date by 25 additional calendar days. So anyway, then it says election. The defendant must file a request for trial by written declaration, and that's the form. Now, see, here's where it gets a little confusing. You can request trial by written declaration in writing. And then they have a form, TR-205, which is entitled Request for Trial by Written Declaration. And those are two different things within the meaning of this section of rules of court, by the way. And if you read on helpiguideticket.com, there is a section on trial by written declaration, which explains this probably better than what I'm doing. And it goes into that little technicality that most of your court clerks will not know. They don't understand that. And that's okay. They don't really have to, but you might be able to put them through some mental anguish or something if you wanted to. I wouldn't try to do that. I don't try to, when I go to traffic court, I wouldn't be trying to make enemies or trying to make the clerk look stupid or something like that. Although I did write the presiding judge one time and tell him that his court clerk was not applying this section correctly, and then they had to I guess they had a little discussion with the court clerk, because eventually the court clerk did comply with the rules of court as they're supposed to. So anyway, the written form is, or the form you can get online or that the court clerk will send you, is the TR-205. With the clerk, let's see, the defendant must file a request for trial by written declaration, which is that form, with the clerk by the appearance date indicated on the notice to appear, or the extended due date as provided in number 2. And number 2 is where you might have requested extending the due date. The request for trial by written declaration form, TR-205, must be filed in addition to the defendant's written request for a trial by written declaration. So that's, you might have made a, you could make it on a napkin, I guess. You might have made a written request for trial by declaration. That must be filed in addition to the form, which is called request for trial by written declaration. Hopefully that's not confusing to you. I understand it. I'm hoping you understand this. Unless the defendant's request was made on the election form. I'll have to admit I don't exactly know what that means. Let's see. Okay, bail. The defendant must deposit bail with the clerk by the appearance date indicated on the notice to appear, or the extended due date as provided in number 2. So here, the extended date as provided in number 2, that's the within 15 calendar days, the clerk must extend it by 25 calendar days. That's when you must deposit your bail. And the other thing is that, and I don't know if this is in this section or not, but you must deposit bail with your trial by written declaration. Now, I'm going to add something here that I think is a good idea. I don't know if it's not a legal requirement that the court honor this request if you make this request. But if you make a trial by declaration request and you fill out the TR-205 form and you send it in, then I would say if you want to go to traffic school, assuming you're convicted by TBD, and let's say you live in San Francisco and you got your ticket in Bakersfield, or you got your ticket in Monterey, or somewhere where it's far enough away that you don't want to drive down to the court, you may want to complete all of your legal wranglings, if possible, by TBD, which is, and filling out the TR-205 form. And you might be acquitted at that point, but you might also be convicted. If you are convicted, or regardless of whether you're convicted, I would send a separate check with your bail amount. I would send a separate check to the court in the amount of the court fee that accompanies the, hang on, I gotta check this and see if I got an important message or not here. All right, nothing major. Okay, so where was I here? The defendant must deposit bail with the clerk by the appearance date indicated, or the indicated on the notice to appear, or the extended due date is provided in number 2. Do this trial by written declaration. Let's see. Then it's number 5 in this case. It says instructions to arresting officer. If the clerk receives the defendant's request for trial by written declaration form TR-205 and bail by the due date, the clerk must deliver or mail to the arresting officer's agency the notice and instructions to arresting officer form TR-210 and the officer's declaration form TR-235 with a copy of the notice to appear and the specified return date for receiving the officer's declaration. After receipt of the officer's declaration or at the close of the officer's return date, if no officer's declaration is filed, the clerk must submit the case file with all declarations and other evidence to the court for decision. And so what that means is that if that officer, for whatever reason, does not respond in time to the clerk's request for their statement on the TR-210 form and that stuff, and TR-235, then that file goes to the court and the judge will make a decision. And as long as you didn't admit guilt in your TBD, which you should never do, you should never admit factual guilt in your TBD. Just say, I respectfully stand by my not guilty plea, if anything, unless you have evidence that you believe supports your innocence in the case. That's as far as I would go. I would just say, I respectfully stand by my plea of not guilty, and then call it good. And then that would be the end of my statement, unless I had something meaningful to say. And something true to say. Obviously, you don't want to lie on the TBD because it's going to be submitted under penalty of perjury, for one thing. So if the officer doesn't respond, you're basically off scot-free. If they don't send in your pictures, if it's a red light camera case, they don't send in your pictures, you're basically scot-free at that point. After the court decides the case and returns the file and decision, the clerk must immediately deliver or mail the decision and notice of decision, which is form TR-215, to the defendant and the arresting agency. That's pretty self-explanatory. Trial de novo. If the defendant files a request for new trial or trial de novo, which is form TR-220, within 20 calendar days after the date of delivery or mailing of the decision and notice of decision form TR-215, the clerk must set a trial date within 45 calendar days of receipt of the defendant's written request for new trial. The clerk must deliver or mail to the defendant and to the arresting officer's agency the order and notice of decision. The order and notice to the defendant of new trial, trial de novo form TR-225. If the defendant's request is not timely received, no new trial may be held and the case must be closed. So that means if you don't send your or hand deliver to the court your request for trial de novo on the form TR-220 within the 20 calendar days that they're talking about, then your case is done. And if you were convicted at trial by declaration or trial by written declaration, then you're finished. You won't appeal, you won't have any kind of recourse at that point, as far as I know. Okay, the case and time standard. The clerk must deliver or mail the decision and notice of decision form TR-215 within 90 calendar days after the due date. Acts for which no specific time is stated in this rule must be performed promptly so that the decision and notice of decision can be timely delivered or mailed by the clerk. Failure of the clerk or the court to comply with any time limit does not void or invalidate the decision of the court unless prejudice to the defendant is shown. Due dates and time limits must be as stated in this rule unless changed or extended by the court. The court may extend any date, but the court need not state the reasons for granting or denying an extension on the record or in the minutes. And that basically means that if you call the clerk or the judge or whoever else and you request something in writing or on the phone or however you want to do it in person, if they extend time frames for you at your request, they have the right and the opportunity to do that. And if they have your money already, there's really no reason they shouldn't do that. And as I said previously, the more you extend, the better. You don't hardly, I can't think of a single reason why you would want to invoke a right to a speedy trial in this situation. There may be cases, and I don't know what those would be, but at this point, it's just most likely to your benefit anytime you extend any date or any time frame. Because the longer you do that, the more likely the officer is to quit, or forget what happened, or lose interest in the case, or go to a different division or a different assignment or whatever. And you don't know when that's going to happen, but I can tell you when that's going to happen. It's just going to happen. Someday the officer is going to retire. Someday the officer is going to get a promotion or something. And you don't know when that is. And whenever that is, all the traffic cases are probably going to be dismissed. They might go to court on something, I don't know, but they're going to be onward and upwards to better things. Okay, ineligible defendants. If the defendant requests a trial by written declaration, the clerk of the court determines that the defendant is not eligible for a trial by written declaration. The clerk must extend the due date 25 calendar days and notify the defendant by mail of the determination and due date, or in this case, a due date. If the defendant, this is a non-compliance, if the defendant does not comply with this rule, including submitting the required mail amount, signing and filling all required forms, and complying with all time limits and due dates, the court may deny a trial by written declaration and may proceed as otherwise provided by statute and court rules. Under evidence, testimony and other relevant evidence may be introduced in the form of a notice to appear under Vehicle Code Section 40500, a business record, or a sworn declaration of the arresting officer, and on behalf of the defendant, sworn declaration of the defendant. Fines, assessments, or penalties. The statute and the rules do not prevent or preclude the court from imposing on a defendant who is found guilty any lawful fine, assessment, or other penalty, and the court is not limited to imposing penalties in the bail amount unless the bail amount is the maximum and the only lawful penalty, which usually is, but there may be civil sanctions or something like that if you gotta have, I guess, or whatever. Additional forms and procedures. The clerk may approve and prescribe forms, time limits, and procedures that are not in conflict with and not inconsistent with the statute or this rule. Then it has a list of forms. There may be some local forms that a court may adopt, but they must not be inconsistent with this, with the procedures and the rules of court. So, anyway, trial by written declaration, always do that. Always. There's never a reason not to do that. And one of the best reasons to do that actually is when you go after if you get convicted at TBD, if you go into the court, you can see that case file. So before you go in for a trial, you know the officer will appear probably, or if they don't appear, you'll be acquitted at that point, or charges will be dismissed at that point. But if the officer shows up and you have that case file in your hand, you can make copies of the case file. And you can make copies of any statements that the officer made. And then when the officer testifies in court, if any significant way, if they deviate from what they wrote in their Form TR 225 or whatever, the 235, their officer's declaration form, you can use that to impeach their credibility. If it's a significant issue, if it's just that they said it was a Tuesday and it was a Monday or something, I don't know if that's going to fly or not. But if it's something serious, like they got the one, they're saying your officer was traveling east in their declaration, but they're saying it was traveling west in court or something like that, that might be a serious impeachment of their credibility to the point where you could say that the officer is not a credible or a competent witness. And the court might disallow the officer's testimony, or maybe in making their decision, they might decide against the officer based on the lack of competent witness or the lack of recollection that the officer has. I don't think the officers want to lie or anything. They might, but I don't think they're going to do that. But usually, they might, in the best case for you, they might forget what they saw or they might testify that they saw something what they didn't see. And in this case, the written statement they made at the TR 235 form is it's a statement under oath. It's a statement under perjury, and you can definitely challenge their verbal testimony if their oral testimony if it's different from their written testimony. And it's just good to know where they're going with their prosecution of the case before you actually hear it in court. If you see the TBD statement of the officer, that might give you some idea as to where you can challenge their credibility, or where you can prove their line of thinking or whatever is wrong. But you don't know that unless you go down to the court and see your case file and look at the officer statements or whatever evidence that the officer might have put into the file. Anyway, that ends my discussion of the trial by written declaration form. And like I said, I would go to helpigotaticket.com, look at that website, and see what they say about trial by written declaration.